Hi everyone, and you're very welcome to today's training session. So today we have three presenters. First up we have Laura Murphy, and Laura is going to provide an Irish employment law overview. Laura is an experienced human resources and employment professional with experience gained both in-house and externally in consultancy roles. Over the course of her career, Laura has gained substantial experience with SMEs, international organisations and public sector bodies across the UK and Ireland. Joining Laura today is Paul Byrne, and Paul is the Managing Director here at at Thesaurus Software. He is also a Chartered Accountant, having previously spent over 20 years working in accountancy practice, where he also managed a busy payroll bureau. Today, Paul will give you an insight into our HR software package, Bright Contracts. Today, we are also delighted to welcome our guest speaker, Alan Connolly. Alan has worked in practice for over 20 years and is a partner with BCC Chartered Accountants and Registered Auditors. Alan is here today to give his thoughts on Bright Contracts and to discuss how the software has helped BCC accountants who have been using the software for the past 4 years. We will have a Q&A session at the end of today's webinar where you can put questions to all of our panelists. So you can type questions into the questions bar at the right of the screen throughout the webinar, and we'll try to get through as many questions as possible afterwards. Today's webinar is also being recorded, so we will send out a link to the recording of the webinar to all attendees afterwards, along with the presentation slides. Today's webinar is CPD accredited, and attendees can benefit from 1 CPD hour. So if you need a certificate as proof of attendance, please fill out the survey at the end of today's webinar, and we'll send out the certificates within the next few days. So I'm now delighted to pass you over to Laura to begin today's presentation. Thank you.
So, good morning, and thank you all very much for attending today's webinar. The main purpose for today is to give you an overview of Irish employment law, and we look at some key pieces of legislation, and we'll also be looking at contracts of employment, and I'd like to give you a bit of an overview of the different types of contracts. As a practicing accountant, hopefully this will help you in terms of understanding your clients and giving them advice, and hopefully as well for your own practices as well. We'll then be looking at a simple solution to help you hopefully increase your revenue as well. As I'm sure you're always looking at different ways to kind of be able to provide different services for clients and attract new clients, and hopefully what we have here today will help you with that. I've put up a brief agenda at the side, and as Rachel has already said, we'll take any questions and answers at the end. So to get started, just looking at employment law and payroll, and when you look at the two of them, there are so many aspects that overlap. Whether it be annual leave, maternity leave, working time or minimum wage. And as an accountant, if you are already looking after a client's payroll, I'm sure the chances are that you are already providing advice to clients around some of these issues. So when it comes to employment law, you probably know more than you thought you did. But I know from our experiences here in Thesaurus Software, there are so many interconnecting factors between payroll and basic employment obligations. So in terms of our own support team, there are definitely, the two definitely overlap quite regularly. So again, for yourselves, practicing accountants, it makes perfect sense for you to have a basic knowledge in this area, and even more sense if you can in some way amalgamate the two for the benefit of ultimately for both you and your client. And the issue, I suppose, when we look at employment law is that it's always changing, it's forever changing, and keeping on top of those changes can be a real challenge for small employers, particularly when you think about it. It's regardless of whether you have 2 or 200 or 2,000 employees, employment law is the same, and the same rules and regulations apply to everybody, whether you have the resources for a full-time HR department or not. And even so, we look, for example, in 2015, for example, we saw some massive changes, some of the biggest changes in our employment landscape that we've had in over 70 years. And again, with more changes set for 2016 as well. So I just want to give you kind of an insight into some of those changes. The first one was the introduction of the WRC, the Workplace Relations Commission, and this came in October 2015 with the Workplace Relations Act. So this is the body that looks after all employment relation disputes and the correct implementation of employment law in Ireland, if you like, in the workplaces. Up until now, we've had several different bodies. We had NERA, we had the LRC, we had the EAT, the Employment Tribunal, and we had this very ad hoc system, and different tribunals and different bodies dealt with different issues in different areas. And it was very much, the whole system had very just much evolved and reacted to different legislation as it came in over the last number of years. So this piece of legislation is probably really well overdue, to be honest with you, and it just amalgamates all those bodies into one. So now we have the WRC, they look after all claims. You're probably used to hearing their name on the news at the moment, the Lewis and the SIP2 situation that's going on. So the whole aim of it basically is to speed up and simplify the process of claims. And so it's brand new, so we wait and see how that's going to turn out. But as I said, it's a long overdue piece of legislation. The next change, just to go through with you, is minimum wage. So you'll all be familiar with minimum wage. That increased to $9.15 in January just gone. The point to note, I suppose, with this piece of legislation is for the first time that we now have a low pay commission set up. So the commission has been set up to advise the government and the minister around pay and the minimum wage, and they'll advise the government on a yearly basis. It's not to say we'll have a change in minimum wage every year, but they'll definitely be reviewed on a yearly basis. And then the next change happened in, this was back in August, 1st of August, where we had to change the Organisation of Working Time Act, where employees can now accrue annual leave whilst they're on sick leave. And with this change, it's when you are on certified sick leave. So more often than not, this is people who are on long-term sick leave for that. So they can now accrue their annual leave whilst on sick leave. So moving on then, we also had a new ERO, an employment regulation order in two sectors, the contract cleaning and security industries. This came with a new Industrial Relations Act that we have brought in again in October. So an ERO is an agreement which sets out specific pay and working conditions for workers in specific sectors. And the terms of these agreements generally go beyond basic employment law legislation. So, for example, minimum wage for security has now been set at $10.75, and for contract cleaning, it is $9.75. Moving on from there, we also have paternity leave. This hasn't come in yet, but it's set to come in September 2016. Up until now, we've had no paternity leave in Ireland, and we were very much behind the times compared to our EU neighbours. So this piece of legislation will very much kind of move us along in line with them. The plan, I suppose, at the moment is that there'll be accommodation for 2 weeks paternity leave, and it is planned again that will be paid similar to maternity pay at €230 per week, whereas that changes. The obligation, obviously, there's no obligation on the employer to pay that. That's paid through the state, but obviously employers need to update their policies and just be aware of it and make sure employees are aware of that when it comes in September. And then the final change that I just wanted to show you was a review of, back late last year, I suppose the Minister, Jen Nash at the time, requested a review of 0 hours and flexible contracts to find out how they're used in Irish workplaces. I suppose these types of contracts, they're very useful for employers in helping them meet fluctuating business needs, and particularly if you think of small businesses, and for them to have the ability to call in employees as and when they need them. However, there's obviously a counter-argument then on the employee side, in that there's no guarantee of work or pay. And if you cast your minds back again last year, we had cases where Dunn Stores workers were going on strike because they were on 0-hour contracts and flexible contracts. So that whole review was to kind of see where we were at there, and the aim of at the time was to maybe establish some different legislation in the area, whether that would be minimum notice period that you would have to give an employee of work, or a minimum number of hours. Unfortunately, we've now obviously had the general election, and this is all kind of left and it's up in the air. So we'll see where it goes. If and when we form a new government, I'm not sure where the priority will be on that, but it's there at the moment, and it's open for discussion. So it'll be an interesting change if it does come true, because I think it will change the face of how we work with contracts, and particularly for small employers who need that flexibility. So it's a watch this space for the moment. And so that's just a quick overview of what's going on and what's happening, and I think you'll probably agree there is quite a lot going on, and it is obviously a challenge for small employers to keep up with that. But I want to move on then to give you a bit of an overview of the existing employment law and what we have in place at the moment. So we have over 30 pieces of major employment legislation, and we'll look at those key pieces, and I suppose it's good to work out that the need for organisations to ensure compliance with legislation is really growing, and it's greater than ever as we have more inspections and we have greater claims and obviously the risk of fines as well. And the first piece of legislation that I want to talk about is the Terms of Employment and Information Act. So this piece of legislation sets out that employers are obliged to provide an employee with a statement containing the basic terms and conditions of their employment. So basically, this is generally a contract of employment. So again, legislation states that all employees must receive a contract of employment. And so I've set out there that the recommendation is to roll out contracts of employment. Again, legislation here states that contracts must be given within 2 months of an employee starting with you, and best practice, I suppose, that I would advise people would be to get them even before an employee starts, or really when they start that first week, because it's a good kind of way to start the employment relationship. And we will talk about contracts in a lot more detail later on. But just say we often get questions, I suppose, when we're advising our customers on the right contract side, is to say, well, I've got, people say they've employees who've been working with them for a number of years and they don't want to implement contracts now, or is it possible even to implement contracts once you have somebody who's been with you for 4 or 5 years, or whatever the case may be? And we would always say absolutely yes. It's never too late to implement your contracts, because if and when you have an issue without a contract, you're really on a back footing straight away, and it's so much harder to deal with any kind of issues without a contract. But we'll, again, as we go through today, we'll have a look at kind of key reasons why you need contracts. But just to say, the first piece of legislation is the Terms of Employment Information Act. Moving on then to the Employment Equality Act, and this really is a large piece of legislation, and when it was introduced, I suppose, in 1998, it really was a thought-leading piece of legislation. So what the legislation states is that it is unlawful for an employer to discriminate on the grounds of gender, civil or family status, sexual orientation, religion, age, disability, race, or membership of the travelling community. And you're probably familiar with them as the nine protective areas. And you're not permitted to discriminate at any stage of the employee-employer relationship with this, so that's just worth pointing out. So right from the recruitment side of it, in terms of your job adverts, obviously it's the ultimate case probably going back a few years ago, where Ryanair were advertising for the young dynamic person, so you can't use those phrases in your job adverts. And right through your training, your promotion and termination, whether that's redundancy or whatever it may be. The Act also defines harassment and sexual harassment, putting an onus on employers in this area. And so in order for employers to endeavour, I suppose, to remain compliant in this area, I've set out policies which I think you really should have, that will act as a guide and a starting point in terms of preventing any kind of discriminatory behaviour in your organisations. So there would be a bullying and harassment policy, an equality policy, and a forum for grievances to be raised, so a grievance policy. Now, whilst it's not a legal requirement to have these policies in place, I really would highly, highly recommend it, because when we talk about our WRC and the bodies that kind of came before that, they publish codes of practice in this area. So that's kind of how serious and that they place the onus on these policies, that they have a code of practice that employers really should follow when it comes to these areas of bullying and harassment and equality and grievances. So it really is in the best interest of employers to have policies in this regard. And if you ever, God forbid, are brought down to a tribunal or a WRC adjudication, they will stand you so much in good stead, I suppose, having these policies in place. And if you do have these policies in place, for example, with the grievance procedure, you really should be following them through. So if somebody comes to you, a tribunal will look to see that you as an employer went through your procedure fully and you went through every step. So it will back you up and protect you there. But equally, turning it on its head, if an employee was to bring a claim against you as an employer, the tribunal will first ask to see did they proceed down the grievance procedure that's in place. And if they didn't, well then that's obviously not going to look in favour for them. It's a massive piece of legislation, and it's a piece that employers need to be aware of. Looking now that our new WRC came into effect in October, and some of their new cases, or their first cases, if you like, are starting to come through now, and we're seeing the results of them. And just looking at them yesterday, there's quite a number of equality cases that have come in. So these are brand new cases, and they've only been decided, or decisions have only been reached just in January. So just to give you a kind of a taste or a flavour of the types of decisions, there was a baker who was working for a large multinational retailer, and they were working in the bakery department, but their GP had issues saying that they had multiple sclerosis, and that the work in the bakery department was quite heavy duty, and could they be moved, and they should be moved. It was recommended that because of this disability they should be moved to a different department. This individual's contract actually stated that they could work in other departments, but the employer never moved them, or they didn't move them, and they said at the time they couldn't move the individual. That individual was ruled that yes, there had been disability discrimination, and he or she was awarded €30,000 for that. And this is just actually to note, it just got into my head, all these new determinations with the WRC, the ruling is given, but the names of the claimant and defendant aren't given, so they're all confidential. There was actually another case that I wanted to touch on as well, and when we talk about age discrimination, and we talked about discriminating right through the employer-employee relationship, we talked about termination. This was an age case where a worker was selected for redundancy based on their age, where younger workers were retained and the older worker was terminated. So that individual won their case as well, and they were awarded €12,000. So this is to give you an example of the types of cases that there are, and the types of awards that are being issued. And as I said, these are current. These have just been issued in January, just gone. So just to give you a taste of that. Very briefly then, the protection of employees. So these are acts that again protect your, I say, atypical worker, although flexibility is coming in more and more. But the general thought of these acts is to prevent these type of workers from being treated less favourably to comparable full-time workers. Obviously, the part-time and the fixed-term workers acts, they were quite some time ago, but in 2012 then we saw the agency worker came in. And obviously your agency worker will be slightly different than your part-time worker, because your agency worker is employed by the agency that they've been provided from. And so it's key, I suppose, in that regard, that to remember and to ensure that there's correct documentation to state that the agency worker is employed by the agency, so your contract there will be important. And I suppose that just sums up this slide in this legislation. It's important to get the right contract and the right wording in place, just to ensure you've kind of covered off that area. The Organisation of Working Time Act is another massive piece of legislation, and when we talk about payroll and employment law overlapping, this is probably one of the key areas where it does. And I know it's a huge portion of our calls, probably both on payroll and on the HR side, which will come in from the organisation, come in and around the Organisation of Working Time Act. And the Act governs all aspects of working time, such as rest periods, weekly rest periods, Sunday working time, and maximum working time. So I'm going to go through the key points of it very briefly for you. So an employee, maximum working week must not exceed 48 hours. Rest breaks, if an employee works 4.5 hours, they must receive a 15-minute break. If they work 6 hours, they're entitled to a half-hour break. And there's also a stipulation for daily rest periods, so employees should get a rest period of no less than 11 hours between shifts in any 24-hour period. The Working Time Act also stipulates annual leave entitlement, so each employee is entitled to 4 weeks paid holidays, and we can calculate that obviously with the 8% for more kind of flexible hours worked. Key again to note for a lot of small employers and employers who don't know, employees should not be paid in lieu for their holidays. And obviously then again, all employees are entitled to a benefit for a public holiday, whether that's a day off or a day's pay. And also for part-time workers as well, they will receive a benefit as well. Key to this piece of legislation, I suppose, is the record keeping, and I can't emphasise that. It's really important that correct records of employees' working times are kept. And just go back to my recommended action in the slide. when we talk about the Employment Act earlier, when we were saying that we need contracts of employment, it's very important that actually also stipulates that details of hours worked are included in the contract of employment. So that's a key point for the Organisation of Working Time Act. Moving on then to our family-friendly rights. This isn't a piece of legislation in itself, rather I'm just including a number of different pieces, namely the maternity, adoptive, parental, carers leave, and force majeure, and I suppose from September they're looking at paternity leave in there as well. So these forms of leave are often referred to protective leave because they protect because of the protection that is afforded to employees on this leave. So employees' terms and conditions of employment are very much protected whilst they're on any of these leaves, and generally they have a right to return to the same position that they held before they left. So again, this is protected. The key point here, I suppose, is to have appropriate policies in place, and I've seen it so often where companies will say, somebody goes on maternity leave and she's paid, and then somebody else goes on maternity leave and they decide, oh, well, we're not going to pay in this instance. And that's just a really dangerous position for employers to be in, because that inconsistency, and again, WRC adjudicators or tribunal judges, they're not going to look favourably on inconsistency. So having the right policies in place here can really protect you when it comes to these issues. Just briefly, I suppose, before I move on here, there was a kind of an idea or a movement that we would have one kind of family leave act that would encompass all these pieces of legislation. It hasn't come to fruition yet, but we wait and see, and maybe it will in the near future. Very briefly, minimum notice in terms of Employment Act. So there is, again, legislation sets out minimum notice that employees and employers must give if they're terminating the contract of employment. If an employee is leaving an employer, they have to give 1 week's notice, and then the amount of notice that an employer must give differs depending on the length of service. And I've set that out there for you. I suppose just to note here that, if you think about it, and if you've got maybe a long-serving member of staff or a key employee, and they go to leave, if you haven't kind of accounted for it in your contract of employment, they only really need to give you 1 week's notice. And the question then for yourself as an employer is, well, is that enough? Can I do a correct and full handover in a week to get all the information that they have, to get all the contacts, to get their daily processes and their duties, and equally, is a week long enough to hire a replacement or to get somebody trained up? So it's worth thinking about that when you're doing up your contracts of employment. So again, minimum notice is key to have within your contract of employment. The last piece of legislation that I want to go through with you is the Unfair Dismissals Act, which is really, again, massive, and we've got a huge amount of questions on it, and I think most employers at some stage in their working life will come up against it when they've got somebody who's not working out, it's just for whatever reason isn't working out, and they want to dismiss them. And even that transfers over to, when we look at the amount of cases that are held in the tribunals on unfair dismissals, it's the number one reason for cases. And if I just move on one slide briefly, in 2014, almost €5 million was awarded in unfair dismissals cases. It averaged out about 17,500 per case. But that's the highest amount that was awarded in any kind of one area, so it's a key area. So I suppose to give you an overview of what the legislation states. So if you're an employee and if you're looking to dismiss somebody, if they have 1 year's service with you, if they're over the age of 16, and if they have yet to reach their contractual retirement age, then unfair dismissal legislation applies to them, and there are certain steps that you need to take. You need to be particularly careful and cautious if you were looking to dismiss that employee. Alternatively, you're going to find yourself at the end of one of those large claims. So the processes that you need to be aware of, and there's kind of two fundamental principles when we talk about unfair dismissals. And the first one is that an employer must have substantial grounds on which to terminate a contract of employment, and secondly then that fair procedures must be followed when completing the termination, I suppose. And the two really go hand in hand, and there's been so many cases where it seems like there's been an obvious termination, and it seems so obvious that you would terminate an employee for whatever the case may be, but processes and fair processes weren't followed, and the tribunals then find in favour of the employee. There was a case recently enough where there was a truck driver or a guy who drove for work, and on a couple of occasions he was turning in for work under the influence of alcohol, and obviously therefore not capable of carrying out his duties. So the employer, they moved and they terminated him. He brought his claim in due course, and the tribunal found in favour of the employee because fair procedures were followed. So that's just to give you an example. And when I talk about the recommended action in unfair dismissal cases, it really shouldn't be recommended but almost compulsory action, because legislation again states that all employers must give employees within 28 days of starting a written procedure on how dismissals would work in their company. So this is effectively and usually included in your disciplinary procedure, but it is in legislation and you must apply it. So if you take anything from today, well, that's one of the key points that I would stress, that dismissal procedures really should be in place, because if you go to a tribunal and you haven't a dismissal procedure in place and somebody has dismissed somebody, you'll find it very hard to defend the case, and the adjudicator is not going to look too kindly on your case. So moving on from there, and as I said, we talk about contracts of employment. I think hopefully at this stage you've now gathered that your contracts and your policies are key to kind of keeping abreast of employment law changes, and they are, because they act as a guide. So the contract of employment, to focus in on that, it is the cornerstone, and it's the key to your employee-employer relationship, and it really is the foundation of it. We did some research a couple of years ago, and when we found that 60%, for that 60% of you're probably wondering what it is, but we found that 60% of employers do not have contracts of employment in place. And I suppose considering this figure is so high, it's probably the chances are that quite a few of your clients may not have contracts in place either. So for myself, coming from an employment background, employment law background, HR background, I find this figure incredible. It is a legal requirement. We're after seeing that it's a legal requirement for all employees to have contracts in place, yet such a high number don't. And from an employer's perspective, it's also quite shocking, really, considering the consequences that they're leaving themselves open to by not having contracts in place. And we'll just look at some of those consequences now. So the cost of non-compliance, or the cost of being found to not have a contract of employment in place for your staff, is 4 weeks pay per employee. Now, you're the accountants, not me, so I'll let you do the sums, but if you have even a small amount of employees, 4 or 5 employees, and they have a small average weekly wage, that figure can add up quite quickly, and soon you'll be finding that you're kind of owing 15, 20 grand, which in my experience when dealing with small employers would not be easily swallowed, I suppose. So just to make you aware, there is fines for not having your contracts in place. Contracts of employment can also offer you really further protection, and not having clearly documented terms and conditions of employment can really leave you open, I suppose, as an employer. And I'll just give you a further example of that now. So an agreement between an employer and employee is usually made up of 2 terms: express terms, and those are the terms that are usually written down, and they're part of their read and they're part of the contract, and implied terms, which are usually unwritten and tend to have developed over time. Implied terms can be formed either one of 2 ways: as a result of law, for example minimum wage, or as the result of custom and practice. And a custom and practice is a practice that is developed over a period of time or by arrangement. But the issue with custom and practice clauses is that they've never really been specifically agreed upon by either party, so they're very much open to disagreement as to exactly what's involved or what the terms are. And just to give you an example of this, there was a case again. It was down around the downturn in the economy, and it was a printing company who, up until that point, had every year given their employees a bonus or a Christmas bonus. But in the downturn, they found they were unable to pay bonuses. They just didn't have the funds, whatever, that year. So they decided against paying bonuses. The employees of the company brought a case against the employer to say that custom and practice actually stated or would suggest that they were entitled to the bonus. And in that case, the judge again found in favour of the employees, saying that in order to establish a fair, reasonable and just approach, that the bonus should be paid. So I think this is a great example of showing where your contract can really protect employers. If that printing company had a small clause in their contract saying that bonuses, something very simple, bonuses are paid at the discretion of management or will be paid on review, something very small like that would have protected them in that case, and it would have prevented the customer practice clause. It would have been a express term, it would have been agreed upon, and they wouldn't have found themselves in the tribunal facing those fees. So that's just an example of the protection that contracts can give you. I often come across this mindset amongst employers that, it's never going to happen to me. But the reality is that it can and it does. And in terms of compliance checks, both planned and unplanned workplace inspections are carried out on Irish businesses. Previously, these were carried out by NERA. You're probably not familiar with NERA. NERA now falls under the WRC Commission, and inspections are carried out by workplace inspectors. And actually, these workplace inspectors, they actually have increased powers to NERA, including the ability to issue on-the-spot fines. So I've included a graph here just to give you a kind of a taste of the types of inspections and where they're taking place. But in 2014, NERA carried out almost 6,000 workplace inspections, both random and planned. As you can see from the graph here, the food and drink industry is obviously a key area for inspectors, and many prosecutions, we've just been talking about this before we came on today, but many prosecutions have actually been made against employers in the sector. But however, what's clear to me as well from this graph is the spread of industries that have had inspections. And even if you look at this kind of the larger light green section of the pie, I suppose, that's the other type of industries, the other, if you like. So really there's quite a large spread. So I don't think, looking at this graph, that really any employer in any industry could really safely sit back and say, well, this will never happen to me. Just briefly, this is another case I just wanted to tell you a little bit about, because it kind of goes back to our unfair dismissals that we talked about, but it's also kind of looking at the protection that having proper contracts of employment and policies in place can give you. And this is somebody who's actually using our bright contracts now, but when he came on board and we were talking, he was telling me he has a hairdressing business. It's just in a small town, small, it's not a chain, it's an independent hairdressing business. They had a number of staff, everybody was quite friendly, small company, as you're probably aware. It's almost like a little family, I suppose, and he never thought anything was going to happen to him. Lo and behold, for whatever reasons, they ended up having to dismiss an employee, and 6 months later then he got the notification that she was bringing a claim against him. So he went and he got his legal representation, which obviously was costly in itself, and he went to the tribunal. At the tribunal, the first thing the judge said was, well, where is your company handbook? He didn't have one. Where's your dismissal procedure? He didn't have one. Where are your training procedures? He didn't have one. Where's your contract of employment? He didn't have one. So he was on the back foot automatically. He never actually got a chance to put forward his case or his legal representation. The judge automatically ruled the case out, and they awarded $25,000 to the employee. So I don't mean to scare you too much, but that's a real life example of the protection that you can have if you have your correct documentation in place. So I suppose all that leads us on to, well, who gets a contract of employment? And something that I come across quite a lot is when employers say to me, well, sure, I've got 5 full-timers and they all have contracts, but I've no other staff, they might say to me, and look, lo and behold, it turns out, well, I only have 2 weekenders and they come in and they do a few hours for me, but sure, they're not staff, I don't need contracts for them. And there seems to be this myth amongst employers that you only need contracts for full-time employees, which simply isn't true, to be honest with you. So basically, anybody who is on your wage bill should have a contract of employment in place. So we'll just look at that briefly. Obviously, your part-time workers, even if it's 1 evening a week, even if it's a Saturday morning, really you should have a contract of employment for them in place. Your seasonal workers, if it's somebody coming in over summertime to cover extra workloads, if it's the Christmas rush, whatever it is, the seasonal worker, again, really should have a contract in place. Your temporary workers, whether it's somebody coming in for a fixed term or a specific purpose, whether they're working on a particular project or covering maternity leave, again, really put a contract in place for them. And your casual worker, so the person, again, that you call in when somebody rings in sick or when you have a particularly busy workload, and you don't need them all the time, you can't get them guarantee hours, but again, going back to, we touched on casual hour contracts earlier, you really should have a contract in place for them. And as much as all of them are important, sometimes I think the casual worker, where there's so much ambiguity, it's really key to have contracts in place for them. So as I said, anybody really who's kind of on your wage bill should be looking to put in written terms for them. And as I said earlier, ideally it should be, or legally they should be given within 2 months. But I'd be really advising people to get the contract before somebody starts, or at least in their first week. And then we're looking at the different types of people that we give contracts to. Well, are there different types of contracts that we give them? And yes, absolutely there are. So we'll just touch on them. Obviously the permanent contract, this is a contract where you have no end date specified. So the intention is that the employee will keep working with you into the future. They can also be called indefinite contracts. Just to note, someone on a permanent contract doesn't have to be full-time. Equally, a part-time member of staff can just as much be a permanent employee. Obviously, you've got your fixed-term worker, so they will have a fixed-term contract. So for this person, they're being employed for a limited but definitive period, and you have a predetermined date in mind as to when they'll finish working with you. We also have specific purpose contracts, so this is where somebody is being employed on a specific project or replacing somebody, probably again at maternity leave. You don't have a date in mind, but it's determined between the end of a project. It's a purpose. Obviously, then you have temporary as well, again, where the person is being employed for a limited period of time. And then the last two, again, that we've spoken about quite a bit, the casual workers and the zero-hour workers. The casual contract exists where there are no fixed hours and there's no continuing relationship, and the individual may be contacted when required and offered the opportunity to work, but is under no obligation to accept. Your zero-hours contract is similar to the casual contract, but the employee is obliged to accept hours that are offered. But again, you have to compensate them for time that they have to be available for work. So it's the two, the casual contract and the zero-hour contracts, that are under review at the moment. And it could be a case that, when we get our new government, that the two will be amalgamated, or that we'll see a change. We're not quite sure yet, but that's how it stands at the minute. So move on briefly then to actually what should be, what should be contained in our contract of employment. And if we're going back to our Terms of Employment Act that we spoke about at the start, this sets out specific terms that must be in your contract. And we've touched on them, we've touched on a few of them going through our different pieces of legislation. So you'll see there the name, address of the employee, employer, the job description, and duration of the contract if it's a fixed-term contract, hours of work, going back to our Organisation of Working Time Act, the rate and calculation of pay, minimum reference to minimum wage, paid leave, sick pay, pension details, and again, notice of termination, which we spoke about as well. So these are specifically included in legislation that must be included in our contracts of employment. But going beyond that, I would always advise employers to put in some additional content into their contracts for two main reasons. A, because it's going to provide greater clarity to the relationship between you and your employee, but also to protect you as an employer or your clients, giving you a fallback and a point of reference. So just to go through some of the additional clauses that I would suggest, but I'm saying these are not a kind of an ultimate list, and very much the type of extra clauses that you include in a contract will very much depend on your company, the individual, the role itself, your industry, a number of factors. But just to give you an overview of these probation, this is a really important clause in terms of managing your employees, paying in lieu of notice, post-termination restrictions. This can be particularly useful for even for yourselves as accountants. If you have somebody who's leaving and you don't want them to go off and start soliciting customers or clients within a certain time frame as soon as they leave your company. So this could be a really important clause for yourselves as accountants. Then we have layoff and short-term working. Time and attendance is a great one to include. Just helps you manage cases as they may or may not arise. Confidentiality clause, again, another key clause for even yourselves as accountants. I'm sure you will have employees who have access to certain confidential data, even for your customers' data. So a confidentiality clause will be key as well for there. And the final one, reference to your company rules and norms as well. So that's reference to your company handbook. And that leads me on to, you'll probably be delighted to hear my final slide, put onto the company handbook as well. So the company handbook contains all your employee policies and procedures, and your policies and procedures are descriptions of how all your employees, regardless of their job or their title, and how they're expected to conduct themselves. So your employee policies and procedures are generally contained in the employee handbook or company handbook. And it's a great opportunity for you. The handbook is a great opportunity for you to tell people how they're expected to act and what they in return can expect from the employer. Make no mistake about it that the essential document in the relationship, in the employee-employer relationship, is the contract of employment. However, that said, the staff of the employee handbook can be an incredibly useful tool as well, especially in terms of communicating those policies. And I recommend having both, and I recommend giving both at the same time, and they got to go hand in hand. But the beauty of the handbook is what you want really is to have a concise contract of employment. You want to keep it detailed, you want to keep just what you have to have in there, because that's the agreed contractual arrangement. The handbook then is going to be a larger document. I think our basic standard one is about 36, 40 pages, and that's where you want to have all your extra policies and procedures in place. And it gives you that flexibility. If it's not a contractual document, you can change it much more easily as well, and amend it from time to time. But I just have I've concluded there the types of policies that you include in your handbook, and you're familiar with them all at this stage from having gone through the presentation, your disciplinary, your grievance, your bullying and harassment, your family-friendly rights, and all the leave entitlements. And again, just make sure if you have set clear boundaries, it ultimately kind of gives less of opportunity for disagreements and disputes in the workplace. So it's really, really important. So at that point, that said, I think I'll leave it there. I know Paul is eager to get going here. So I think we're just going to take a short break just while we kind of get Paul set up. So thank you very much.
My voice is a little bit off because I've just got over a dose of man flu, which any of those men listening out there will know it's a very serious and life-threatening condition. So anyway, first of all, what we can see from employment law is that it can be a minefield, particularly for small employers who don't have HR expertise to deal with employment issues, but also don't have the time to be dealing with these issues. And finally, don't have the resources to be using expensive employment solicitors or consultants. With this in mind, we have created Bright Contracts. Bright Contracts has been designed and created with small businesses in mind. In a nutshell, it's intuitive software that creates and manages contracts of employment and staff handbooks. Before I go on, I'll explain myself briefly and explain why I have any right at all to be talking on this matter. In 1991, I co-founded Thesaurus software to provide payroll software to businesses who were at the time struggling with manual systems. It was a case of being in the right place at the right time. I am an accountant by qualification, but a nerd at heart, and this dates back to the late 70s, which in turn makes me very old. All is good though, as I surround myself with highly talented people who cleverly mask any shortcomings I may have. From 2013 to 2015, I was chairman of the Payroll Software Developers Association in Ireland, and although this sounds very grand, it was unpaid and very dangerous, as it put me in plain view of some very senior revenue people. But that's enough about me. In supporting our customers with their payroll for over 20 years, we've naturally become finely tuned to the needs, concerns and worries of small businesses across Ireland. Of those concerns and worries, employment law comes to the forefront time and time again. It seemed to us that many Irish employers were anxious over the massive employment law landing at their doors. However, although frightened by news reports of large settlement claims and irrepressible bad press, for the reasons I've already alluded to, many businesses we spoke to were adopting a head-in-the-sand approach to employment law. As we've already heard from Laura, not complying with employment law really is a costly option. To solve this problem, we developed Bright Contracts. And Bright Contracts was designed to make compliance with employment law accessible, affordable, and simpler for all Irish employers. Today, Bright Contracts offers equivalent benefits as our payroll software did all those years ago. Bright Contracts takes the headache out of employment law for employers. Although a new product with a new concept, it is something worth getting your head around. No longer is there a need for companies to use the services of expensive solicitors or engage in lengthy services agreements with HR consultancy firms. Bright Contracts can do it all while still retaining all the quality and precision that is required in contracts of employment. Very quickly, the key features of Bright Contracts are: contracts can be completed by answering a few simple questions. A complete, ready-to-use handbook is available for all businesses. We keep the software up to date with employment law and HR best practice changes. Users need no HR knowledge. Support is available online and at the end of the phone. Bright Contracts is the perfect solution for accountancy firms or other bureau users looking to add an additional revenue stream. We have designed 3 different options for you. The main one is become a bureau user, and then the other ones are become a referrer or become a reseller. Bureau customers. As a bureau customer, you purchase a bureau license for just €599. A bureau license will enable you to create unlimited contracts for unlimited employees in unlimited client companies at the click of a button. As a bureau customer, the sky's the limit in terms of how much you can earn. By offering the bureau service, you will not be taking on any additional liability. If you use the software as provided by Bright Contracts, we take all the responsibility. Offering the service really is a win-win for accountants, and Alan Connolly from BCC Accountants will give you some more insight into the practical aspect of this in just a minute. We also offer partner agreements. As a partner, you can become a referrer or a reseller, both of which will give you opportunities to increase your revenue. Further details on our partner agreements can be found on our website, www.brightcontracts.ie. Okay, so that's the end of my little slot here. I'm just going to pass you over now to Alan.
Thanks, Paul. So this figure on the screen here, €9,660. I was actually really surprised that this was the amount of money that we'd actually taken in from Bright Contracts last year. I suppose I'd never really looked at the figure before. It was only as part of this presentation when we'd been asked how much income we'd actually derive from it. To be honest, for me, the income from Bright Contracts wasn't the main driver. It was all about solving a problem that we'd encountered over and over again. So we've clients not providing employment contracts to their staff, or adapting various out-of-date versions of Word documents downloaded from the internet. So at BCC, we've been offering employment contracts through Bright Contract software since 2012. It's become an integral part of our client offering, with over 20 clients using this service on an ongoing basis. So it certainly gives you a competitive advantage when quoting predominantly for payroll bureau business, but even using the software internally for our own employees has been excellent. It's been so easy to use. At the start, there was definitely some skepticism about offering this service. The main concerns we had, that we'd no employment law expertise, so how could we provide the service? Would we be taking on, let's move this down, would we be taking on additional exposure that we hadn't any experience in relation to? How do we advertise the service? Would there be any interest from our existing clients and potential new clients? And would we make any money, or would we at least cover the cost of the software? So briefly on these, on the cost front, I'd gladly pay the €599 to cover the cost of our own staff employment contracts, but the fact that it's actually generated such a healthy income stream has been a real bonus. We've helped improve our clients' compliance, providing robust employment contracts and handbooks, but at the same time we're not really providing HR advice. Our clients complete a straightforward questionnaire which is produced by the software in relation to each position that they want to fill. So we're really only inputting the information they provide. So we're 4 years on, and there was really no need to worry in relation to how it might progress. So in relation to approaching our customers, this is really our approach, but it's everybody can adapt this to whatever suits themselves, but it's certainly things that we found worked. I suppose in terms of when we generally engage with clients at the start, it's a service that we can offer in addition to maybe the accounts preparation services or income tax, payroll, consultancy. So now employment contracts is just something that's been tagged onto that. We do remind our clients of their legal obligations to provide pay slips on a regular basis, but also to have employment contracts in place. Initially, we sent out a number of dedicated emails to inform our clients that we were offering the services, outlining the cost, etc. And a number of clients signed up at that point. Actually, after listening to Laura's presentation, I think we should be more active in relation to that, because it's only when you listen to that presentation you realise how important an area it is. We included details on our website, and we do have a quarterly newsletter which we send out, and we regularly remind clients that they have a legal obligation in relation to this area. There are many aspects of payroll that overlap with employment law. As an accountant for many small and medium businesses, we're often the first port of call, as most accountants would realise. When the issue arises in relation to holiday pay or sick pay for employees, it's a good time to remind the clients of the importance of contracts of employment, and the employment contracts need to be set up to cover these areas. All in all, it's fitted in really well with our existing services, and with minimal amounts of additional work required from a marketing point of view. Our bookkeeping staff think it's excellent, and it's certainly very easy to use. In terms of the workflow and actually doing the work, offering contracts just slots in with our workload. For clients that have signed up to the service, when we're running the client's payroll, if we're adding a new employee to their payroll, we simply create a new contract for the employee as part of our payroll process. Software is so straightforward, literally takes minutes to complete, and I suppose the more and more we've used it, the easier that has actually become. But unlike payroll, once the contract is created, it's done. We do offer a discount for amendments to employment contracts when people want to make a change to a contract. So it's not the same cost that we charge initially. We just literally offer or charge them an administration fee in relation to it. In terms of gathering the data to create Bright contracts, as I was saying earlier, it's made very simple. The Bright Contracts Bureau Service Toolkit is available on our website, and it provides a range of really useful documents and resources, one of which is the employee contract checklist. So our bookkeeping department would send out the simple checklist to the client, and at the same time we send on a request for payroll information for the new employee. And the client completes both requests together and sends them back. On completion of the payroll, we send over all pay slips to the clients, and at that stage we will also send over the contract of employment and normally a copy of the handbook as well. The contracts can be exported from the software into the PDF, so we can easily email them over to the clients and they can print them off and give it to the employee. So it's really that simple. Just in relation to the legal responsibilities in providing the service, it was something that we were concerned about obviously at the start, but once we use the software in line with how Bright Contracts has set this out, they hold any liability. On the rare occasion that a customer is asked for something specifically to be included in the contract, we're able to phone the Bright Contract support line where we receive full support in making the change. And we've had a number of clients, say for example, that would have specific circumstances like intellectual property that they need to include in the contract, and you can imagine how exposed they would be if that wasn't in the contract in terms of how protected they are. We've had several clients that have had near inspections where, or supposedly it's called the WRC inspections now at this stage, but I still actually thought it was under NERA, but anyway, they've scrutinized the contracts of employment, and any client that we've had that has had a near inspection with Bright Contracts documentation has actually gone very well. They've passed, and they've hence avoided the fines and the bad press that go along with that. So we certainly have total peace of mind and trust in the product. I have to say that in a market that's become increasingly competitive, Bright Contracts has really offered us something extra to help us stand out, and I'd certainly highly recommend that you consider using it.
Okay, Alan, thank you very much for that. What we're going to do now is we have a few questions and answers that have come in, and any other questions that you feel you want to input into the sidebar of the GoToWebinar screen, please feel free to do so now. And I think Laura will be taking most of these questions. She's the she's the expert here. Okay.
Okay, so I'm just trying to read and kind of trying to understand it as I go as well. Would annual leave accrue for people on sick leave? What is the procedure for calculating annual leave for part-time workers? Well, I would imagine annual leave for people on sick leave would be calculated kind of as it would have been if they were working. So maybe for part-time workers, it depends really what their working arrangement is. It would be, again, it's either the 4 weeks or 8% of their hours worked. Maybe, if I'm understanding why you're asking, if they're maybe more casual workers and obviously they weren't working, so how do you know what their hours were and on what basis to calculate their holidays on? I would do it on an average of before. What were the hours that they worked before they went on sick leave? And you take a set period. I think generally kind of a good time frame would be the 13 weeks prior to them going on sick leave, and calculate their holiday entitlement from there. It's worth saying that this new legislation that came in August is not backdated. So if you had somebody on sick leave from June 2015 to November 2015, for example, they would only be entitled to annual leave entitlement from August. So that the period of leave June to July, there would be no entitlement there either. And also to state on this one, it's a confusing area and there are lots of questions on it, and I'm certainly happy to take more direct questions, but when somebody accrues annual leave during sick leave, they have a 15-month period in which to take it. It's only carried over for 15 months as well, so it's not indefinite, so it just kind of adds an extra kind of a restriction on it, I guess, to help. So hopefully I'll answer that in some way. I think the key is if they're out on sick leave and they're not working, so it's difficult to calculate their hours, go for an average of their hours prior to them going on sick leave.
Again, I think this is another question for you, Laura. I'll just read it out for you. If the only employees are directors and owners of the company, so typically a small family-owned company, are employment contracts still necessary?
Generally, if you're a director of the company, so you're not an employee, you won't generally need a contract of employment. There is some, in particular we're talking about different legislation that applies when it's unfair dismissals acts as well. Family members, if it's a family member, there's no real restricted, they're still an employee, but if they're a director, then they're going to be they're not an employee as a director.
I presume we're really talking about proprietary directors there.
Yeah.
Because you could still have a director who only has a minority shareholding or not even no shareholding at all. So I suppose in those cases you still need a contract of employment.
Yeah, I guess it will depend on the type of director there.
I suppose I think the question really relates to somebody who does have a majority shareholding or husband and wife maybe or something like that, so they wouldn't necessarily need a contract in that case.
No.
There's a question in here for me. Is there a facility on Thesaurus payroll to enter details if an employee has a medical card? Actually, do you know something? I don't actually know the answer to that at the moment in the 2016 version. I know we did have that in a previous version, but because there are different types of medical card now, there's full medical card and there's GP only, and I suppose it determines the USC status and the PRSI class. I think all we ask now is, well, for the USC, we get that in from the P2C import from the Ross website, or employers would do that. For the PRSI class, I'm not actually sure whether we ask it anymore, so I can get back on that one. I'll email that person with the answer to that one.
Just another one coming in. What happens if an employee refuses to sign a contract? That's a question we get quite a lot. The onus of the legislation is really around the employer, and it's the employer's responsibility that they must provide and sign a contract of employment. There's no legislation that sets out that the employee must equally sign it and return it. So what I would do in that situation is it's very important as an employer that you keep your record and your paper trail of having given with a contract and communicating it. And it's very much about communication with the employee. And in my experience, where we've had difficult or trickier situations in terms of reaching agreement, it's very much about the communication, being open to communication with the employee and open to taking their questions, and if there's a particular reason why they're not signing it, and kind of going through that process as much as you possibly can, because it's all about being open in this process. You're not asking an employee to sign anything untoward. It's very much usually what's in practice already. And so through communication you can generally try and prevent that, but absolutely there are cases where the employee won't. So all we're to say is keep your track record and keep your paper trail that you have gone through the process. Generally, again, by virtue of the fact that the employee is coming into work every day and accepting a pay, they are in some way accepting the terms and conditions as well.
Okay. Another question, I think, for you, Laura. How do you handle a situation where an employee never takes their full annual leave and has a build-up of leave carried forward from year to year?
Well, the onus is on employers to try and arrange for employees to take their annual leave. And I know very much from our point of view here, we very much keep on top of people's annual leave and remind them that they have X amount of days left for the remainder of the year. And actually, as an employer, you can state when an employee takes their leave. So, you know, if we have somebody in here who isn't taking their leave, we can actually say, well, the next 2 weeks you're going on annual leave to use up your entitlement. I'm not so sure about the carry forward. Generally, you can stipulate that employees aren't allowed to carry forward leave from 1 year to another, and I'm not sure how that would really work if it was challenged that you'd somebody carried over leave for 2-3 years. It's not really a practice that's done too much. I would really be putting the onus back on the employer, because it's a working time act regulation, so you're kind of you're in breach of that if people aren't taking their leave as well. So I'd be putting a bit of onus on the employer to try and allow people, not allow, I'm sure you're very flexible with leave as well, but try and promote that people take their leave, and maybe try and see if you can put some curtailments in terms of carrying over leave.
Okay, thank you, Laura. I'll take the next one. So basically the question is, I operate Thesaurus Bureau for many companies. Is the Bright contracts charge for contracts of €599 a once-off payment? No, it's actually it's an annual figure. At the end of the year, if you don't renew, you'll still be able to access information within the Bright contract software, but you won't be able to create new contracts after that date, nor will it update for the updates we issue regularly for employment law updates or for changes to the contract or handbook. So it is a yearly charge, and it also covers the any questions you have that you can email us or phone in, and Laura or a team will be able to answer particular questions that you have, and maybe on behalf of your clients. So it's the answer to that is it is an annual figure.
And just probably to kind of on the back of that, so with 2 licenses, if you were just even almost interested for your own practice, you have just a standard license at $399 as well for one company. There's another company coming in, and I'm regarding an employee who has changed name and changed their PPS number, who is a non-national. I probably really need to know a little bit more about this case in terms of you're asking what's the legal obligation of an employer, because first and foremost I'd probably be asking the question, are they legal? Are they legal to work in the state? And a PPS number is not, it's not confirmation that somebody is legally entitled to work in the state, because obviously somebody could get a PPS number and then their work permit expires. So a PPS number isn't a confirmation that they're entitled to work in the state. If it's actually the same person, you would as well have to recognise their length of service from the date they started as whatever the first name was. So I'm not entirely sure of the question. I don't know, Father, maybe we can see any other angle to come from that one. And maybe you want to drop in an email with more detail, and we can maybe advise a little bit more on it separately.
Okay, yeah, I can't think of anything else to add there. I think that's it. We've gotten off very lightly here. I thought there'd be loads of questions for you, Laura, since they have the opportunity. Oh, hang on, there's another one coming in. Sorry, just as I say that, there's a few coming in here now.
Does Bright Contracts include payroll function? No, Bright Contracts is a separate product. It's a standalone product. It does talk to the source software you like in terms of importing employee data, but it's a separate product on its own. So the fee, the $399 to $599, just for the Bright Contracts.
Okay. Next question here is, what is the situation for recruitment companies with regard to the legal responsibility to pay redundancy to temporary contractors with over 2 years service?
That's going to really, again, depend on the fixed term contract that was in place. But first and foremost, an agency staff member is not an employee, so generally speaking, they wouldn't be entitled to redundancy as they're not an employee. A temporary contractor, a contractor again would establish that they're not an employee. It's a contract of service rather than a contract for service. So I'd be unsure as to their entitlement at all to any redundancy payment. If you're talking about fixed term contracts, somebody who is on a fixed term contract with the company, yes, there's a question as to whether they'd be entitled to redundancy. But again, that'll all very much depend on the type of fixed term contract that they were given at the time. So yeah, it
Just follow up to that question there. Just clarifying, I think, what the activities of the contractor are actually, sorry.
Yeah, if the client company gives the duties, the contractor, the recruitment agency or the paymaster, so the people who pay the person, there's a number of different factors, I suppose, that you consider as to whether whether a worker is an employee or not. And both of them are saying, the employer or the company gives the work, but the agency pay them. The agency probably are looking after their tax affairs. I'd be inclined to be on the side that they are an employee of the agency rather than the company. But again, we probably have to look into that one a little bit more.
Okay, next one here. I think it's one we come across. It's quite a controversial one. An employee on sick leave, long term, has no notion of returning to work. How can the employer handle this situation, bearing in mind the new regulations with regard to annual leave entitlements?
Okay. Firstly, I don't really think the new regulations with regard to annual leave entitlements won't really affect too much how you handle this situation. Their consideration, absolutely. But in terms of handling an employee on long-term sick leave, we could talk all day about it, and we've had webinars on it just as that. The key thing I would say is keeping in contact with the employee, and it's very much key to keeping in contact with the employee. People say, people ask me, can I? Certainly you can. For the first while, when somebody's off on sick leave, you're kind of setting up the arrangement, how we're going to keep in contact. But then definitely once that sick leave extends and goes forward, you're keeping in contact with an aim to establishing when the employee is coming back. And if you're saying here there's no notion of them returning to work, that's what you have to establish. And if somebody is not coming back to work because of the capability, and when we talk about unfair dismissals and fair reasons for redundancy, fair reasons for dismissal. Capability is a fair reason for dismissal. So if somebody is not capable to do the work, then that would be a fair reason to terminate them. So absolutely, I would say yes, you would be looking towards terminating that employee, but the process that we talked about, that second step, you have to get that process right. And the first step of that is getting in contact with the employee and getting some two-way communication going. So that would be the main thing there.
Yeah. Next question here. In Bureau version, all handbooks are the same. I think we have in by service, few different trades.
I'll take that. Okay. Well, our standard handbook in all of our contracts is the same for everybody, and we've written it so that it's kind of generic across the board. Absolutely, that it will apply in many different organisations. But the beauty of the the handbook is that we have made it totally flexible and you can make changes wherever possible. So absolutely, if you have a bureau version, you'll have different companies and you'll be able to go into each of your individual companies separately and you'll be able to make changes that are applicable in each company, and they will only change in that one company. Those changes won't reflect in all your other companies. So you can tailor them as much or as little as you want to.
Okay. Next one. If somebody is out sick awaiting hospital test results, will return to work, are the company insured? But the return to work, presumably while they're awaiting the test results, are the company insured to have them there without clearance from doctor?
It's a bit of an open question. I'm not quite sure, again, the details and what the test results were or what's the illness. I'd probably go with somebody has been signed off work for a period of time by a doctor. I would not be taking them back to work until that period of time has elapsed. So sometimes a doctor would sign somebody out for a week, and if somebody's coming back before then, I would probably, best practice would be, yes, to get some sort of clearance from the doctor to say they're now fit to return to work.
Okay, the next one I think is for me. How much for Bright contracts for an individual client per year? The single company version of Bright contracts is €399 per year. And next one here, should community employment participants be given contracts by the sponsor, i.e. the employer?
The employer, yes, I would generally say yes, I'd be giving them a contract as well.
And next one, could we get some clarification in relation to lunch allowances, evening meal allowances, and overnight allowances payable to employees? I don't know what the clarification there is in terms of what's revenue.
Well, they have the civil service mileage rates and civil service subsistence rates that are available, so that's generally what we would use.
I'm just wondering, is there a question there in relation to, is that something that needs to be included in the contract? Or?
It's not, it wouldn't generally be, and it wouldn't be, they're not generally accommodated as part of your minimum wage, where, for example, you can take, if you provide somebody with lodgings or board, there's an amount that can be deducted from minimum wage in relation to you're providing with board and lodgings, but this doesn't apply in terms of lunch allowances, so I think it's probably just a revenue question.
Yeah, it is a revenue question.
Okay, I think we're going to leave it at that now, and I'd like to thank Laura and Alan for joining us today, and thank you all for tuning in, and leave it at that. Okay, thank you very much.